Good morning, everybody. It's just gone 11, so we're going to start. Can I welcome all the councillors, all the officers and the members of public who are both present and who are watching on our YouTube channel. My name is Councillor Amanda Rigby and I'm the chair of the Licensing Subcommittee. I will now introduce the other members of the subcommittee and ask that they confirm that they are present. Councillor Steve Hedges.
Present, Chair.
Thank you. Councillor Karen Warrington.
Present, Chair.
Thank you very much. Also present are Terrell Wallin, who's our Senior Licensing Officer, Shane Lewis, who's the team leader of the legal team, and we also have Emphys Hughes from the Democratic Services. This meeting is being held under the Local Authorities and Police and Crime Panel's Coronavirus Flexibility of Local Authority and Police and Crime Panel Meetings, England and Wales, Regulations 2020. The Council has agreed a protocol to cover virtual meetings, and this meeting will act in line with that protocol. This meeting has the same status and validity as a meeting held in the Guildhall. Could I remind all councillors, officers and members of the public to keep background noise to an absolute minimum, to only speak one person at a time and not to speak over others. Please mute your microphones when not speaking and then unmute when invited to speak. Please indicate if you wish to speak by using the chat facility on Zoom by typing MIS, may I speak, and you'll be called to speak in turn. That applies specifically to the members of the committee. If a member of the subcommittee has to leave the meeting, then please draw my attention to this by using the chat facility, as the meeting will need to adjourn as 3 members are required at all times. When returning to the meeting, please also draw my attention to this in the same way. Members should also inform me if they lose connection and if they miss any part of the meeting. Can I just go around and check who else we've got in the room? We've introduced ourselves. Can I just check, do we have Mr. Charambolides in?
Ma'am, yes. Good morning.
Good morning.
Here.
Thank you. Do we have Nicola Smith?
Good morning. Yes, I'm here, Chair.
Lovely. Thank you very much. Do we have Jonathan Walker? I can see you speaking, but I think you're on mute, but I think I saw you.
Yes, I am here.
Thank you very much. Do we have Mr. Arthur Dyer? I'm seeing I've got non-video participants at the top of my screen. Can we just hold on for 1 second and I can see who we've got? Show non-video participants. Yes, we have I can see Mr. Dyer is here. Do we have Reverend Neil Potting? No, we don't currently. He may join us later, I am sure. Can I move on to item agenda number 2, which is apologies for absence and substitutions. Emphys, have we got any apologies or any substitutions?
No, we haven't. Everybody, all the members of the committee are present.
Perfect, thank you very much indeed. Declarations of interest. Councillor Hedges, have you any declarations of interest?
No, Chair.
Thank you very much. Councillor Warrington.
None, Chair.
Thank you very much. And I don't have any declarations of interest either. Item number 4, to announce any urgent business agreed by the chair. There isn't any. Item number 5 is the licensing procedure. Can I ask specifically Mr. Dyer, Mr. Walker, Ms. Smith and Mr. Charambolides if you have received the licensing procedure?
Ma'am, yes, we all have. For our part.
You all have. I am just going to be completely belt and braces and just run through it, specifically maybe for people who are watching on our YouTube channel as well. And can I also say, if we get at any stage in the meeting and you feel that you don't know quite where we are, then please ask and I will explain what positions we're at. So what will happen in a minute is there will be a summary and update by our licensing officer who will sort of present the issues to us. And then the applicant for this, which in this case is Mr. Dyer and potentially the Reverend Potting, will present their case, and at that stage they may call witnesses. Then the applicant will be asked questions by the other parties and the members. In order to make this run as smoothly as possible, I require that all the questions go through me as chair, so it doesn't end up in any kind of debate, should we say. At that stage, if there are any other parties, they come and they present their case and they give witnesses to the best of my knowledge. And I would like either Envis or Terrell to confirm this. We don't have representatives from the police or from the environmental protection. Is that correct? Perfect, that is correct. So we won't be doing that bit. And then we have the stage where the licence holder presents their case. And we will ask questions, the members will ask questions, and the applicant is able to ask questions. And again, the same rules apply. They all have to come through me. We then get to a point where the licence holder sums up, and then the applicant for this review sums up, and we go into private session, make our decision, come back and communicate it to you. In the interest of fairness, I give both sides an equal amount of time, which is 20 minutes. So when you are presenting your case, either as the applicant or the licence holder, you will be limited to 20 minutes. And my advice to you is you spend those 20 minutes talking about things which are both licensable activities and or impact on any of the licensing objectives, because 20 minutes isn't an awful amount of time. And if you spend time talking about things that I will ask our lawyer whether or not we can keep into account when we make our decision. And if he gives us the advice that we can't, then you are wasting your 20 minutes time. Is all that clear? Have I said anything that anyone is in any way unclear about?
No.
No, everything's clear. Perfect. That's really good. In that case, can we move on? Terrell, would you like to present, please, for us?
Thank you, Chair. Good morning, everyone. This hearing is to determine a review of premises licence application made under Section 51 of the Licensing Act 2003 by Mr. Arthur Dyer and Reverend Neil Pocking in respect of the Bird Bath, 18 to 19 Pulteney Road, Bath BA2 4EZ. The current premises licence is detailed in Annex 3 of the report and authorises the sale of alcohol for consumption on and off the premises Thursday to Saturday from 10 to 0100 hours the following morning, and Sunday to Wednesday from 10 until 2300 hours, with 24-hour supply to residents and their guests. Regulated entertainment by way of the exhibition of film, indoors only, every day from 10 to 2300 hours. The performance of live music, indoors only, Thursday to Saturday from 2300 to midnight. Playing of recorded music, indoors only, Thursday to Saturday from 2300 until 0100 the following morning, and the provision of late night refreshment, indoors only, Thursday to Saturday from 2300 to 0100 hours the following morning. In addition, the playing of music within the outdoor areas of this premises, as detailed within the red line of the plan, has been partially deregulated by the government when played anytime between 0800 hours and 2300 hours on any day. The application states the grounds for review relates to the effect of the premises is having on the prevention of public nuisance licensing objective, attributable to, but not limited to, the playing of dance music from 10 AM until midnight within the external areas of the hotel, which has been described as intrusive, noise emanating from the premises caused by patrons gathering in the cocktail bar, noise from an elevated jacuzzi that abuts the boundary wall, and general noise from persons attending events in an area that was historically the hotel car park. Copies of the application were duly served on all the relevant responsible authorities, and notices were placed both at the premises and within the licensing office. During the statutory period, no representations were received in support of the application or in support of the premises. During the statutory period, a variation of designated premises supervisor application was submitted, varying the nominated person from Christopher Hardwick to Jonathan Walker. Additional information in the form of emails, photographs, links, images, and videos, and a statement submitted by the applicants for review have been circulated to all parties in advance of this hearing. A witness statement, complete with annexes, submitted on behalf of the premises licence holder, were also circulated to all parties in advance of today's hearing. No representations of objections were received from responsible authorities. Public nuisance by its nature is not a matter for this hearing. nor is planning, which is a separate regime. The committee is therefore asked to determine the application. Thank you, Chair.
Thank you very much, Terrell. Before we move on to the applicant, can I just get, first of all, specifically the members of the committee to confirm that they have received all the items that Terrell refers to as having been circulated? I'll go first. I absolutely have received and looked at them. Councillor Warrington?
Yes, I've received, Chair, and looked at them.
Thank you very much. Councillor Hedges?
Yes, I've received and viewed all the documents and videos and stuff.
Excellent. Thank you. Thank you both very much indeed. In that case, can we move on to the applicant? I believe you're, I can't see the Reverend Potting, so I believe it's just you, Mr. Dyer, and you have 20 minutes. Thank you very much indeed. We can't hear you, Mr. Dyer. I can see your mouth moving, but unfortunately we can hear nothing. Can you speak to us? Can we hear you now? No. Is it just me? Can anyone else hear Mr. Dyer? No, good. Well, it's not good that we can't hear him, but it's good that it's not just me. Can I maybe suggest that you, I'm going to ask Mr. Curtis, who is our technical expert on this. Would it help if Mr. Dyer logged out and logged back on again, do you think?
You can give it a go. Yeah, I've just taken him out of the meeting, put him in the waiting room and brought him back in, and that hasn't solved the issue. So
Right.
maybe if you could just switch his machine off, switch back on, and we'll re-let him back in the meeting.
Could you do that for us, Mr. Dyer? And we'll wait, I promise you. Thank you everyone for your patience. Let's hope this works. Just for everyone's info as well, if you wonder why people are looking like they're typing on things, we have a system where all our papers are on an iPad, so that's why we're all looking at them there as well as trying to be on this Zoom call. Are you speaking, Mr. Dyer? Because I can't hear you, I'm afraid. It just doesn't appear to be working. Have you got, I'm not that good at lip reading. Have you got any other device that you could try? Oh, Councillor Warrington.
I wondered whether Mr. Dyer would be able to phone in. There is a facility to phone into Zoom meetings.
Yes. Let's see if we can. I think he's got another device in front of him. That's a very good suggestion, Councillor Warrington. Let's see if we can go this route, because it is better if we can do it with video as well. But if not, okay. I apologise for this, everybody. It's not ideal. Not that it will help you, but this is the first time that this has happened. If you have any good suggestions as well, Mr. Curtis, please feel free to pass them on. And Mr. Lewis, I'm just pre-warning you that if we can't manage to get the applicant on, I'm going to be looking to you for legal advice about what we now do. So I hope I'm giving you pre-warning.
Hello.
Ah, Mr. Dyer, lovely.
No,
Great.
thank
Thank you
you.
very much for that.
My apologies. I'm very sorry.
That's okay. You have 20 minutes. Thank you so much.
Okay, thank you. So I'm just going to read from this statement that I've kind of prepared in advance. So prior to the current owners of this property, neither my family nor I have experienced any problems with the hotel or its activities. I'm not a solicitor or an architect who has any kind of experience of licensing principles or planning. As such, I just didn't really understand what this was or to formulate how the problems were presenting or to whom.
Chair,
The initial management team kept saying all of this was temporary. The application originally was based on this all being temporary, and as such, given that it was temporary, I decided to try and build a positive relationship by not commenting on this, thinking it would just go away. There's a general reluctance to formally complain as to your neighbour's actions. You do have to continue living next to them, and as such, it's got to be fairly significant for you to actually say anything. Tried to provide a variety of different evidence for you to look through, trying to demonstrate the issues, the locations, and providing emails, trying to show you both sides of this problem and where it currently stands. So onto the actual legal statement that's been prepared. So thank you for the council's ongoing input in respect of the review of the various licenses associated deregulation of licensed premises. I consider and I believe reasonably that noise from the hot tub, bar, speakers, groups of attending people, bottling up, waste removal, playing of amplified music from 10 AM to midnight by the Bird Hotel constitutes statutory nuisance pursuant to the terms of the Environmental Protection Act 1990, Part 3, 79G, brackets, EPA. I understand that noise would also constitute an actionable private nuisance in relation to my own residence and potentially a public nuisance depending on the input of others. I note the premise licence being reviewed under the Licensing Act of 2003. Grounds for review relate to the prevention of public nuisance licensing objective under the LA 2003. I would note that the noise is at such an unreasonable volume that noise can be heard throughout my residence, and B is almost constant, can be heard late into the night and throughout the day from 10 AM, which is clearly unreasonable by any objective test. When taken together, the noise would almost unreasonably and substantially interfere with the use or enjoyment of the home in almost any context and circumstance, and does so here. I'd like to point to the private enclave and hot tub areas being a particular problem for this licence. In this location, you've got activities that are regulated by either licensing or deregulation of licensed premises that are occurring outside of licensing hours, specifically playing of music throughout the night. There's also all of these fire pits that have recently appeared. I believe the whole area is actually a smoke-free zone. That's also a regulated activity that's also happening in a licensed area. I would like to also ask you to consider whether there's been any structural damage to our party wall by the erection of a hot tub, speakers, electrical consumer units with failing to apply for planning permission or party wall agreements. If so, it's almost impossible that the Bird are acting reasonably. Given the location of each of the above is probably intentional and may constitute harassment, it's hard to see how the noise could not constitute a statutory nuisance under the EPA. Please note the email from the environmental team who considered the noise intrusive. I'm aware that the council has the power under Part 3 of the EPA to issue noise abatement orders in its discretion. I understand that the purpose of the introduction of noise abatement orders was to try and avoid costly and lengthy litigation. I've lived at number 17 Bath almost continuously since 1995 and did not come to the nuisance. The owners of the Bird have deliberately brought the problems of the nuisance and other intentional violation of property rights. Unfortunately, I have to say that I find it hard to see that the Bird will stop their actions of their own to bring a cessation to the nuisance, especially given the locations and sources of the nuisance. Further, that I've already explored this avenue multiple times without any kind of success. I want to suggest that if the council the chair considers that revoking the licence to extreme, to issue a noise abatement or notice and to push the boundary of the licence zone back inside the building in order to bring this matter to a conclusion. I do not want to hear any unreasonable noise at all, and I would kindly ask that the council considers making such an order with reasonable, justifiable and proportionate request in respect of intentional interference with rights of property. In respect of planning permission or licence, which I suspect the Bird will try and hide behind, I would note that the council are unable to grant and have not granted in this case planning permission to conduct unlawful activity or statutory nuisance. I reserve all of my rights, in particular, to decide whether I consider any course of action agreed between council and Bird have actually dealt with this nuisance. Okay, so that's the statement that I prepared. And do you have any questions? I feel that the videos and the images I presented speak for themselves, and that there's just so much of it there that you're going to have to look through. For example, the jacuzzi area, you've got the photograph of a couple in a hot tub. Yeah, obviously they're drinking in there. Obviously that's a licensed area. All of this stuff is just too much. The Bird have actually significantly developed that site over the last 3 years. They've actually ripped out all of the interiors. They've doubled the number of rooms that they've actually got. They've obviously had to push out into the external area to kind of facilitate their guests. And in this has just obviously had significant impact on us. And obviously they're rubbish, seagulls, rats, waste, noise from their guests, all of it together. It's just too much and it just needs to stop.
Is that the end of your presentation, Mr. Dyer?
Effectively, unless you feel that you need any kind of general more information or you have any kind of questions, I'm more than happy to answer anything that I possibly can. Thank you very much for listening to me.
Fine, lovely. And I'm sure there will be some questions, but before we move on to questions, I am just going to ask Mr. Lewis to give us some guidance. So in listening to what you were saying, Mr. Dyer, you talk a lot about what the council does, and what you're currently speaking to is the licensing subcommittee, which is a separate statutory regime from the council. And some of the issues you brought up, such as party wall, whilst neither thinking that there's been any wrongdoing or not any wrongdoing, that completely falls outside the purview of this committee, as do things like anything that's to do with planning is not something that we can take into account whilst we're making our decisions. So I would like Mr. Lewis just to go through your document, which we have in front of us, that goes through A, B, C, D, E, and give us some guidance as to what this licensing subcommittee can take into account as both licensing objectives and licensable activity.
Yes, thank you, Chair. Well, the grounds of the review, as we're all aware, is the prevention of public nuisance, and you will have to focus your attention on one, the licensing objective of the prevention of public nuisance, and two, how the licensable activity impacts upon that objective. In terms of this review, there seems to be two preliminary issues that you will need to decide in your deliberations. One is the music complained of, in fact, regulated entertainment or incidental, and two, is it a public nuisance? The Licensing Act is very prescriptive in terms of what you can and cannot take into account. And whilst you will have regard to other statutory regimes such as planning, highways, waste, etc., you will focus on the prevention of public nuisance and disregard private matters such as private nuisance, light pollution, party wall boundary issues, planning, change of use, the hot tub, privacy, civil rights, business model, suggestions of competition, intimidation, harassment, and matters arising from the smoke-free zone. So you will effectively have a very narrow remit today. You will not be able to issue any statutory notices in terms of the Environmental Protection Act. That is entirely a matter for environmental protection. So as I say, you need to focus on the license.
You're on mute, Shane.
Sorry, an incoming call. Focus on the licensing objectives and how any licensable activity complained of impacts negatively on that objective. Thank you, Chair.
Well, thank you very much. That's very helpful. I'll move on now to questions to Mr. Dyer, and I'll start with the members. I'll start in reverse alphabetical order this time. Councillor Warrington, have you got any questions?
I do, Chair. I actually have three. I hope that's all right, but maybe if you stop me after a couple. I wanted to ask Mr. Dyer if he'd made any formal complaint in the past prior to this this particular issue.
I had actually emailed on a number of occasions to planning enforcement to ask them to come and actually look at this particular situation since around about 2018. I've forwarded emails of these to Terrell at the licensing office, so she actually has access to this. I just didn't really know or understand quite what this was, and because they'd said it was all temporary, I assumed that if it was going to be temporary, then it would be leaving in a fairly short order, and it wouldn't just be a permanent form of temporary. And that's kind of why it's taken quite such a certain amount of time for this to kind of come forward in terms of complaint. And I've also actually complained to the actual, I mean, I've tried to address these issues to the actual owner and the actual management staffs, largely because of a sense of disbelief. I mean, I assumed this must be some kind of accidental imposition on their part, and that it wasn't deliberate for them to be doing this. But steadily over the years, I've come to realise that they really don't care, and that actually they're just trying to shove as many nuisances in place to try and create as much revenue as possible. And I'm very much just being customer serviced and just handled and managed until I go away, basically.
Okay. So since Mr. Walker took over in I believe it's about November, he says that he's stated that he's taken some action issues such as the hot tub. And have you seen any changes in that?
There's still people in the hot tub area still playing music. There's still people. He is actually still stood there lighting fires in that whole area. He's got 3 different bonfires going that are pouring smoke everywhere.
Yeah, I think the advice from our solicitor is that we can't take that into consideration. We have a very narrow remit.
So no would be. I haven't.
Okay. And when did you receive communications from Mr. Walker in November? And if you did, what action did you take? Did you go and meet him and discuss the issues?
I've been advised by solicitors not to speak to the bird or any of their because of the seriousness of the issues and the seriousness of the problems that they brought here and the implications for me and also for them. The solicitors that I've spoken to have said that it's a really bad idea for me to have any kind of conversation with them. Okay. But I have received a letter. I believe.
Thank you, Claire. That's the end of my questions. Thank you, Mr. Dyer.
Councillor Hedges.
Thank you, Chair. One of the questions I was going to ask has already been asked by my fellow member. That is contact with the bird. Anyway, my other question really is was 2 questions. One is that they've said that they've removed the speakers from the outside. Do you think they've done that?
Mr. Dyer?
So those speakers are actually, as far as I'm aware, actually built into the actual hot tub. So I don't know how you'd remove that from a hot tub that is attached to the boundary wall without planning permission. In terms of the exterior area, I had communicated with them over the summer and I had pointed out to them that they had attached speakers to the party wall and I had asked them to remove it. They're removing it. They took them off the wall and they put them on the ground next to the wall and continued playing music. When the environmental team then asked them to stop playing music, they then attached speakers to the front of the building and started playing music at the front of the building instead. So in terms of whether or not the bird has stopped or is going to stop permanently, I don't consider a letter from them saying that they're temporarily going to stop to be sufficient. I believe that further action needs to be taken to actually remove that from their license. Does that help?
And my final question is, do you think that the noise and harassment that you say you're getting is a form of a way of trying to force you out of business?
In terms of trying to force me out of this, I think it's really problematic. I think it does have a direct effect on the usability of my building, because people just don't want to sleep in a room where you can hear people screaming and throwing parties. There's no less than 3 different links on their website where you can go to their website and you can fill in a form to create a party in their garden or in their building. And obviously this has direct impact on anyone that's trying to sleep in my building. And in terms of it trying to put me out of business, if any of my customers or anyone that stays in my building realizes that they can sue me because I'm not providing quiet enjoyment of my property to them, then they can sue me for not providing the contractually obligated environment. And yeah, certainly it's not possible for me to sleep there because I'm being woken up in the middle of the night by people playing music directly on the other side of the wall, or people even just talking, like up to 500 people sat on the other side of the wall from your building, no less than a couple of meters away, talking. That's incredibly disruptive. And the only reason that all of this is there is because the bird wants to make a higher, more concentrated opportunity for them to create revenue and money.
Okay, thank you very much.
Mr. Dyer, I believe Reverend Cocking has entered the waiting room. Mike, could you admit him? Hello, Reverend Cocking. We have started the meeting, and we're now at the part of the meeting where Mr. Dyer has made his presentation and the members are asking questions. Can I ask you to put yourself on mute, please, and we will continue. In the interest of fairness, as Mr. Dyer didn't use the whole of his 20 minutes, I will also ask you if you've got anything else that you wish to say. But for now, could you please put yourself on mute?
Thank you.
Thank you. It's now my turn to ask questions of Mr. Dyer. I'm focusing on the noise nuisance, as I think that's one of the things that is within our remit to look at. And I'm interested by what isn't here, actually, as opposed to what is, because there isn't anything from the environmental protection team. They haven't made a formal response, and they haven't come to us to say that they believe that what is happening is causing a public nuisance. Why do you think that is?
You'd have to ask the environmental team. I'm not entirely sure, but I've certainly provided you with emails from them in written form that actually state their positions for them, given that they've decided not to present themselves here. And in those emails, they've said that they believe that the noise is of such a level that it's actually intrusive. They've also then taken measures to actually visit both here and actually record all of this particular music. And they've also gone and actually asked the bird to not actually play any kind of amplified music whatsoever. The response of the bird was then to remove these speakers from that particular area, to move them to the front of the building, to attach them to the front of the building, and then start playing music all day long from the front of the building at the same noise level, in spite of being asked by the environmental protection team not to play any amplified music whatsoever. So that's to the most of my knowledge.
Thank you. And that sort of leads on nicely to my second question, which, as the lawyer explained before, we have to be certain that what we're looking at is a regulated activity, and the playing of music in certain circumstances is now deregulated. Do you believe that this music is being used? Is it being advertised as a music venue, or is this just subsidiary to what the other things that they're currently doing?
They're being advertised as a party venue. So they're advertising themselves everywhere, on Twitter, Facebook, on their website, everywhere that I can find. I mean, I think I've sent you quite a few different links. They're saying that they are a party venue and that they are facilitating people to come there from the general public and stand in the garden and be a party venue. And I'd just like to point out, none of that particular area in the garden has actually been rated for any form of business space. None of it is paying any kind of revenue to the council. You know, since 2017, which is when the last business rates evaluation happened of that building, they've doubled the number of rooms, they've created this whole external area, and they've created a massive amount of extra revenue. And I just don't think any of this is appropriate.
Okay, I am going to say, before the lawyer tells me to say it, that the stuff about doubling the amount of rooms, all that is not something that is anything that we can look
But
at. I know it must be frustrating for you.
But it has a direct impact on the number of people that are now gathering on the other side the officer of the wall, and it explains why.
I understand what you're trying to say, Mr. Dyer, but that is not a licensable activity or licensing objective. You may have reason to talk to the planning committee, but that isn't something that we could take into account. Ms. Walling, can you do us a favour as well? About the area that is covered by the licence, could you just explain to everyone, because I think Mr. Dyer was saying that a lot of this was happening in an area that wasn't actually licensed. I think that's what he was saying. Could you just explain to us where the parameters of the licensable area are?
Yes, Chair. The actual plan is in Annex C of the report. So the extent of the licensed on-premise is outlined in red. And so the on-premise is the building and the exterior and part of the exterior area. So for the purpose of the deregulated music, for example, it does extend to that area because it's part of the licensed premises. Does that answer your question?
It does. I think I knew the answer, but I think it's good that we say this in public so that people understand what it is we're talking about. You're shaking your head, Mr. Dyer. Have I picked up what you're saying correctly?
Absolutely. So actually, I think you took the wrong interpretation of what I actually said. I was saying that there is stuff that's actually happening in that area, in an area that is licensed, that shouldn't be. So you've got people playing music outside of the licensed hours. So in the middle of the night, 2 o'clock in the morning, 3 o'clock in the morning, you've got people sat in that hot tub playing music from their phones, or trying to cover their own personal activities, and that is regulated by deregulation of license premises. So.
Okay. I understand what you're saying now, Mr. Dyer. So we move on now to questions from the licence holder and their representatives. I'll ask you first, Mr. Walker. Have you got any questions for Mr. Dyer?
If it's okay, I'll be doing the speaking.
I'm totally sorry. Yes, of course you may.
Just saves time. We don't have any questions in any event, so thank you very much.
Thank you. Terrell, are there any questions that you wish to put at this stage, or no, everything's in the report? Thank you very much indeed. In that case, we do move on then to the presentation from the licence holder and the representatives, which I'm taking is now you, Mr. Cheryl Ambidis. I do hope I'm getting your name correct. Cheryl Ambidis, is that?
Yes, you are. Thank you. You've also mentioned that you might want to ask from the Reverend Cocking, so it's probably more appropriate to
do that first.
Him before you hear from us, so we can hear the full case if he intends to speak. Thank you.
Yeah, no, good point. Well made. Thank you. Reverend Cocking, Mr. Dyer made a very, we've lost him. I think in the excitement to unmute, he may have pressed the leave button. Can I ask all of your patience again? We'll give it a couple of minutes and see if you can log back in. I can see him coming back in, I think. Are you there, Reverend Cocking? Mr. Curtis, can you tell me what the status of Reverend Cocking is? I can see his name and he doesn't appear to have mute next to him. Can you see him?
Yeah, he's trying to get into the meeting, Chair, but at the moment, for some reason, he's not come in. It's not working, unfortunately. I'm still waiting for him to come in.
Thank you. We'll give it a...
Chair, sorry, may I take advantage and take a comfort break?
You may, and we won't start until you're back. Can you make it as quickly as possible, though, Councillor Warrington? Thank you. According to my view, it looks like he's logged out and he's trying to log back in. Is that what you believe is happening, Mr. Curtis?
Yes, Chair. He's tried to come in and it hasn't been successful. We've lost him again. I'm assuming he'll try again.
Yeah.
Technology is wonderful until it stops working.
See, Councillor Warrington is back. Mr. Lewis, can I ask for another legal opinion from you, please? Seeing as how we have started the meeting, we are obviously still quorate, and Mr. Dyer made his presentation, and we did not know at that stage whether or not Reverend Cocking was going to be able to join us. In your legal opinion, should we just continue?
Well, given that the Reverend Cocking is a joint applicant for this review, he will have the right to make representation to the meeting. In the event that he's unable to do so, I would suggest that the meeting would therefore need to be suspended in the public interest, and we adjourn to the next available licensing subcommittee.
Can I just ask you to confirm then, given the fact that Christmas is coming up, I know that we only have a certain amount of days where we're allowed to hear this review, and we have to give a certain amount of notice for the actual meeting. Will that not land us in some alternate legal difficulty because we won't be able to determine it in the specified time, giving the specified notice?
Well, I think we've commenced the meeting. It appears to be matters beyond our control, and it's in the public interest and in the interest of all the parties here today to suspend the meeting in those circumstances, unless we hear otherwise from Mr. Dyer that Reverend Cocking's managed to get in touch with him and said we could continue. Then it would be in everyone's interest to suspend and reconvene in the new year. Doubtless, Chair, you would want to canvass the views of all the other parties.
I will. Yeah, and can I also canvass can I just ask Terrell, do you have a mobile number for Reverend Cocking? Do you have a contact, and or MFIS, do you have a contact, and can you try and see if you can get him on the phone to see if he... Oh, hang on, we've got entered the waiting room again. Let's see if this works. Can you let him in, please, Mr. Curtis?
I have, Chair, yeah. It just takes a little while, bear with us.
Okay, sorry. Ah, Reverend Cocking, hello, can you hear us?
I can indeed.
Okay, wonderful.
Sorry, connection went.
So you've got up to about 12 minutes to make your case, and then we can ask you some questions. Thank you.
Me, sorry, having missed out on something.
Yes.
Yeah. Okay. I support. Right. I support what Arthur is saying. I've owned the property for the last more than 12 years, and it was a respectable residential area. There were hotel, or county hotel as it was, never caused any problems whatsoever at all. And it's only in recent years that there seems to have been a gradual encroachment upon the car park to turn the place into a party venue, all kinds of things. Excuse me, let's turn off. A party venue, sort of pushing the limits, first of all by having a marquee, and then they applied for planning permission, retrospective planning permission, were told they could only have it for Christmas and New Year. Well, it hasn't appeared this year, but in the meantime, we've had the outside bar area, coloured umbrellas, lights, speakers. Now we've got pods, and more recently I noticed there's a blue gazebo. It's become more like a fairground than a nice residential area. I'm not so much immediately affected by the noise as Arthur is, because there are things against his property wall, the party wall. I mean, when they had the disco inside, you could hear the dump, dump, dump thuds in his kitchen. You could certainly hear all the noise from the outside speakers. And it's interesting that even the Bird Hotel says that the guests who have the room where the hot tub is, they provide their own music. So it's not being directly managed, they claim, by the management of the hotel. But as I say, it was a respectable residential, it is a respectable residential area, and now they're trying to make it more like a nightclub.
Is that the end of your presentation? Thank you very much, Reverend Cocking. I will go in the alternate order now for questions to Reverend Cocking. Councillor Hedges, have you any questions?
No, Chair, I don't.
Thank you very much. Councillor Warrington, have you got
No,
any?
I don't have any further questions. Thank you, Chair.
Thank you. I've not got any further questions. It's not that I've not listened and understood what you said, Reverend Cocking, but most of it has been covered in what we've already gone through.
Sure.
But now I will go to Mr. Cheryl Lambidis and see if you've got any questions at this stage.
No questions. Thank you very much.
Okay, no questions. Thank you very much indeed. In which case we are going to come to you, Mr. Cheryl Lambidis, for your presentation. You have, as the applicant did, you also have 20 minutes. Thank you so much.
Thank you very much. And a particular thank you to yourself and to your legal advisor. It's always heartening to see members of civil society engaging in the licensing process, because of course the licensing process is in part for them. However, the licensing process is a very particular legal regime, and you can't say, well, you can say whatever you like really, but you are constrained by relevance. So I'm grateful that both you and your legal advisor have addressed the issue of relevance, which is the primary legal consideration. Indeed, for our part, and I say this only for the record, in the event that I need to on another time, and I need to, I am concerned about whether this application does in fact meet the threshold of relevance as set out in the guidance and in the Act itself. I'm particularly concerned that what we are actually seeing here is a private nuisance, an attempt by a neighbour who may have, we're not insensitive to who may have legitimate concerns, but this isn't the venue for them. It's also by a neighbour with rivaling commercial interests and a different commercial model. And in fact, I'm that much more convinced that the matter is of a private nature, having heard the submissions by the Reverend Cocking, who says that I'm not so much affected by music, unlike Arthur, because of course he shares a party wall. So what we're actually hearing here is a classic private nuisance, and that must be borne in mind. It's one neighbour complaining about the conduct of another neighbour and the way they impact upon each other. And you've also heard that there are issues around planning, there are issues around the Environmental Protection Act. All of those concerns are not relevant to us. And it's not that we are deaf to them, it's just that our legal tribunal, for our purposes today, cannot hear them. Having said all of that, in order to further the conversation, I'm going to proceed as if it were a legitimate application, which, as I said, I don't think it is, and really look to what the purpose of a review is. A review is summed up in paragraph 11.20 of the section 182 guidance, and it asks us to do two very simple things. It's to identify any legitimate cause or causes of concerns, and then to identify any remedial action that might be taken. The Act itself provides you with statutory experts. Those are the responsible authorities, and if they make representations, they're the experts that we are to have particular regard to, but we are to scrutinise particularly carefully. There are no responsible authorities here to advise us one way or another. there is a curated and selective selection of correspondence. What it shows is a credit to your local authority. It shows that Mr. Dyer's able to complain. Your licensing officers go out, or your environmental health officers go out to Mr. Dyer and indeed to the bird bath, and they engage with both of them. There is a conversation, there is correspondence, there are changes that are made. There's the very legitimate to and froing. What there is not any evidence of is any statutory nuisance or any public nuisance. Given the amount of visits that have been had, given the conversations that have been had, it would be clear if there was an actionable nuisance for these purposes, and there is there is not. And in fact, with again respect to Mr. Dyer, he really gets it quite wrong when he says, I don't want to be able to hear anything in my premises. Now, those of us that work in licensing regularly know that noise may be intrusive in the sense that you can hear it, but the fact that you can hear it doesn't make it a statutory nuisance or public nuisance. And we also know in licensing that the High Court has looked at this question of inaudibility and has told us quite categorically that inaudibility as a criteria is itself unlawful. So what I read as not a layperson in the curated correspondence, such as there is a member of civil society being frustrated and not understanding, firstly, private nuisance, secondly, the Environmental Protection Act, and thirdly, the licensing regime, and your environmental health officers understanding that and knowing that there is nothing to take any action here. Nonetheless, we have and continue to work with our surrounding area. We've removed the speakers from the rear. Insofar as the private area around the hot tub is concerned, you've rightly identified that this is a private area. Just to sort of give you an example, if you'll forgive me, maybe because in my time zone I'm well in the afternoon, though I appreciate you're in the morning. If the hotel guests were perhaps engaged in party lovemaking and they were being particularly loud, there is really nothing that licensing can do about that. And it's the same sense, whether they're in the hot tub or using their iPhones to play music, what we're effectively looking at is not licensable activities. Nonetheless, we have switched off the Bluetooth, so we do nothing to facilitate the residents of the room using that music. And of course, we ask them to keep within the confines of what is permissible. We've also put signage in our rooms to make sure that they are mindful of that. So we engage and we do listen. I find it of great concern, and it goes back to my issues about whether this is relevant, vexatious, or frivolous, that having made the effort twice in the context of this application, that Mr. Dyer hasn't engaged with us. I don't know what legal advice he's getting. I don't think it's legal advice from a licensing lawyer because there are no references to legitimate aspects of licensing law contained in any of his representation. But no licensing lawyer who understands the licensing regime would ever advise any person that it is a bad idea to speak to the bird bath. And I feel fortified in saying this, knowing that not only do I have Nicola Smith here, who is a senior licensing solicitor in her own right, but also your own legal advisor, who clearly is well aware of licensing regime. And we all know that it is a really, really, really good idea in terms of licensing law for neighbours to actually respond to an invitation to speak to each other. And you know, quite a part of fact from licensing law, it's a really good idea just to maintain neighbourliness. And so we continue to act in these private issues in the best way that we can, with what I have to say, and I say it very gently, is perhaps a very difficult and somewhat sensitive neighbour. But be that as it may, we will continue to work with Mr. Dyer, and our invitation to talk to him remains open, irrespective of the results today. Ma'am, any response that you and your colleagues make in the event that you do decide that the matter is relevant at whatever level must also be proportionate. The request for revocation is just plainly disproportionate. What you've got in our bundle that we prepared to you is you've got local independent reviews, you've got local neighbours that are really speaking to the asset that this venue is. The way in which the management has changed and the way that we are developing is we're continuing to develop as a boutique hotel, as a destination hotel. The focus is moving towards fine dining, being able to drink and being able to sort of rest in good quality rooms. The focus on the party advertising that was under the previous general manager is being slowly moved away. And you can see the way in which we've operated during the COVID restrictions to attempt to use our outside area in a COVID-based way that's really kind of gripped the imagination of our local residents. And in fact, by way of apology to Mr. Dyer, when I was first sent the emails, I sort of was hurriedly looking through his pictures, and I looked at those pictures and I thought, oh, these are great pictures. Are we using them as part of our presentation? Because I'd certainly be quite proud to show those for a licensed premises to demonstrate the way in which we organise the space, the way in which we operate safely, the way in which we make the best use of the facilities to promote the hotel, the locality, and work with the community. In terms of actions, insofar as there can be, it seems to me that the review crucially starts a conversation. And so first and foremost, insofar as you make any decision, I would ask you and your colleagues to just let Mr. Dyer know that he should respond to our emails and have a conversation with us. And insofar as it's effective and appropriate to do so, we will engage with him. We're already engaging with him and the EHO. We'll do so with licensing if it's relevant. We're doing so with the planning department and we'll continue to do so. We're happy to confirm that we've moved the speakers from the rear of the premises and we've taken the measures that I've set out in respect of how our guests use the hot tub area. Ma'am, the greatest advantage of today is that hopefully, as I said, it will kickstart the conversation, but I would urge you and your colleagues to listen to the application by all means, but to take no further action because no further action is warranted in these particular circumstances. Ma'am, we're all here and available to answer any questions that you might have, and thank you very much for listening.
Thank you very much indeed. And we will move on to questions. Councillor Hedges, I'm going to come to you first. Have you got any questions?
I've only got one, Chair. It's Mr. Dyer says that you've moved the speakers from the back and placed them at the front. Is that correct?
Who wishes to answer that? Mr. Walker?
I can answer that, but as you've asked for Mr. Walker, he can answer that briefly. Jonathan?
So, yeah, sure. Just to confirm, we have not moved the speakers from the rear of the garden to the front. That's not the case at all. There were speakers at the front and we don't use them at all, and they have been removed, and quite happy. We won't replace them, but they were not removed from the back to the front.
What have you done? Sorry, Councillor Hedges, save you coming off on mute. What have you done with the speakers at the back then? There
are no speakers at the back at all. They don't exist. They've been physically removed, so it's impossible to play any music.
Okay, thank you for the answer. Councillor Hedges, have you got any more questions? No. Councillor Warrington?
No further questions, thank you, Chair.
Okay, I may have a question, but I'm going to reserve the right to ask it till we've heard from Mr. Dyer and Reverend Cocking. I'll go in that order. Mr. Dyer, have you got any questions?
I'd just like to point to a couple of things that were actually mentioned there briefly. I think
before you carry on, Mr. Dyer, you will have a chance to sum up at the end where you can make points. We're at the position now where what you need to do, if you have any, is ask questions, not make any comments.
Okay, so is the hot tub area a licensed part of the licensed venue?
No.
Have you noticed that the licence boundary line goes around almost the entire curtilage of the rear of the property?
The licensed area is as set out by your licensing officer and the effect of the Deregulation Act as set out in her report.
I think when you look at the actual pictures of the actual map that shows the licensed premise area, it does include the actual hot tub private enclave area.
Ma'am, the nature of the hotel is such that even though you have the whole licensed area covered by a hotel, it's the nature of the operations. What happens in the private rooms are separate, and it's part of the nuance of licensing. Just to sort of keep things neutral, if you need any further assistance, it's pretty much as has been set out by your licensing officer.
Yeah, and we do have that. That is in the pack that you've also received, Mr. Dyer, I believe. So does that answer your question? I have it in front of me now.
I guess. I mean, from looking at this, it would appear that that particular area is quite clearly within the actual licence and deregulated licence area. And there is obviously alcohol being served within there. If you would have a look at the photograph of couple in the jacuzzi area, they're obviously drinking in that area. That's obviously a bottle of champagne that's been served within the licence area. And as such, that whole area is the licence section.
Can I just ask the lawyer again for a little bit of advice here? Licensing covers the sale of alcohol. I'm guessing that there's nothing to say that the people in the hot tub didn't bring a celebratory bottle of champagne with them. There would be no reason why they couldn't consume that in that area. Is that correct, Shane? Mr. Lewis?
Well, yes, I mean, there's nothing to say that they didn't bring their own alcohol, and consumption isn't a licensable activity. So yes, and many people do bring their own alcohol supplies to hotels. If they had have purchased it from the bar, then maybe it's arguable that if consumption of it is causing a public nuisance and it's directly attributable to the premises, then there may be an argument to do something about it. But it's a publicity photograph, and I don't think we can read too much into it, Chair.
Yeah, thank you for that, Mr. Lewis. Mr. Dyer, have you got any more questions?
I don't have any further questions. Thank you.
Thank you very much. Reverend Cocking, have you got any questions? You're on mute, Reverend Cocking.
No further questions, Mum. Thank you.
Okay, thank you very much. I'm just going to ask one quick question, and it's going back to the public nuisance element. Have you, I mean, I've looked at some of the conditions that have potentially been offered. Do you feel that they would be proportionate under the current circumstances in order to prevent public nuisance, because that is one of the, well, that is the sole reason really that we are here today. What's your view on the proportionality of some of the conditions that have been offered?
Ma'am, insofar as a proportionate response, I think no loudspeakers to be located on the rear terrace. I think it relates to that. We've heard that it's essentially mostly affecting Mr. Dyer, but I can see that there's a potential for further of that. And secondly, to have prominent, clear and legible notices in the external areas and exits from the premises requesting guests and visitors to respect the needs of local residents. Again, that would be a legitimate response to this. There's not been any particular offer of conditions in my submissions. I'd said that it seems to me that we just need to have a discussion, and we've not reached that threshold. You've heard from Mr. Walker that the speakers have been removed from the rear. You've also heard that there is signage in the sort of hot tub in the private area. Again, I don't advise you to put a condition there, but in terms of there being a general notice reminding our residents and guests, as well as our staff, of our responsibilities to the wider area, then I think that would be legitimate. But in my submission, I don't see that there's anything further that could be done on the basis of the application and such evidence as exists.
Thank you very much for your answer. Ms Wallen, have you got any questions that you'd like to? Oh, everything's fine. Excellent. Okay, so we're now coming up to the bit where both parties get the opportunity to sum up. And I think we go with the licence holder first. That's correct, isn't it? Yeah, that's what we do. So, Mr. Shawalambidis, if you could just take maybe 5 minutes, if that's what you need, just to sum up.
Well, I'm grateful that we've started this conversation. It's regrettable that it's come to this. We could have had responses to our emails. We're still open to having those responses to the emails. We welcome working with licensing and your environmental health, and indeed all your other departments, to regulate what is a well-loved, well-established and well-run and managed licensed premises. There are no history of complaints, no issues that have been raised in the circumstances. I would urge you to, as I've said, reject the application for a revocation. At best, I would ask you to accept that we won't have any loudspeakers to be located on the rear terrace, and we'll put up polite notices. That is the most appropriate and proportionate response in the current circumstances. Thank you very much.
Thank you. Mr. Dyer and Reverend Cocking, you have 5 minutes to share between you. Who would like to go first? Mr. Dyer.
Don't mind, I'll go first, please. Thank you very much. So I'd like to obviously thank you for taking time to actually look at all of this. Obviously, because I'm not a lawyer and architect, I've got a serious amount of inexperience about this. They've actually raised the point that, I haven't been communicating with them. Obviously, this has been going on for the last 3.5 years. So for the first proportion of this, I spent a certain amount of time talking to these guys. They just kept on ignoring me. And it gets to the point when you're being ignored and you're asking people to stop doing stuff, that you just aren't really prepared to talk to them. And given the seriousness of the fact that we're now actually having a hearing around all of this, I agree with the recommendation that I've been given by the solicitor that I've actually spoken to, that actually speaking to the bird, in particular, having listened to the council that has just represented and made all of these representations, I don't feel there's anything to be gained by me going and sitting down and talking to these people. And in particular, he's pointed here to me saying that I don't want to hear any noise at all. He's actually left out a particular word in here. It says, I do not want to hear any unreasonable noise at all, which I think is entirely warranted. And I would say having up to 500 people gathering on a wall that's directly next door to you is obviously unreasonable. And further, I don't think that the Reverend Cocking saying that he's less affected by noise is saying that he's unaffected. He's actually not said that at all. He's simply saying that I'm more significantly affected, which is just a slightly different reading or interpretation of the word. But anyway, I'll let Reverend Cocking obviously have the rest of the time, please. Thank you very much. Bye-bye.
Reverend Cocking.
Hello. Sorry, apologies, ma'am. I accept that the management are saying that they have no loudspeakers in the rear terrace. I'd be much happier if they said no speakers at all, because speakers could be playing quiet music. But I think it would be more appropriate if it was worded as no speakers in rear terrace. Other than that, I mean, I'm glad to say that they will diminish the party advertising. And finally, I have to say that I do accept there's a differentiation between the licensing authority and planning consents, which is a separate issue and may be another area to be explored.
Thank you very much. What we're going to do now is we're going to go into private session to reach our decision, and you don't need to do anything about this. The technology will help until you get asked to click on something to go into a different room. Can I ask, obviously, if you need a comfort break, that's fine, or make yourself a quick cup of tea, but can I ask that you stay whilst we're having our debates, because it is possible that we will think of something that we feel that we now should ask before we make our decision, and we need everybody present in order to be able to do that. So, Mr. Curtis, could you please split us into the two separate bits, the committee and everybody else? Thank you. Welcome back, everybody. I'll just wait till we have confirmation we're all back and then we'll start again. Can you confirm when we're all back for us, Mr. Curtis, please?
Yes, Chair, 6 seconds to go.
Thank you.
Chair, everyone is back in the room.
Thank you all very much, and thank you for your time this morning. As licensing subcommittee, we've decided to take no further action, and our legal representative is going to read out our reasons why.
Thank you, Chair. Members have determined an application for a review of the premises licence at the Bird, Pulteney Road, Bath. In doing so, they've taken account of the Licensing Act 2003, statutory guidance, Council's policy, Human Rights Act and case law. Members are aware the proper approach under the Licensing Act is to be reluctant to regulate in the absence of evidence and must only do what is appropriate and proportionate in the promotion of the licensing objectives. Members reminded themselves that each application must be considered on its own merits, and in these circumstances, the objective of the prevention of public nuisance was raised. The applicant for the review stated there had been a number of problems with the premises over the past 2 to 3 years since it had morphed into a party venue. Photographs, video images and emails were produced in support of the application showing the nature of the business model and the nuisance experienced from light pollution, building works, and music and voice arising from the outside of the premises areas. This nuisance, it was stated, is particularly intrusive as a result of attractions such as a jacuzzi, photo booth and marquee placed in close proximity to neighbouring properties. Further, fixtures having been unlawfully attached to boundary walls, and in one instance, water was running off of the shed and being experienced on neighbouring land. The applicants added that with large groups gathering, talking loudly, singing, screaming and listening to music in areas previously used as a car park, the hotel was operating as a party venue, causing neighbours to feel unsafe, intimidated and harassed in their gardens. In response, the Birds representative stated this is a classic private nuisance matter and there is no evidence of an actionable public nuisance in terms of the Licensing Act 2003. Further, there was no evidence from a responsible authority to support public nuisance, and in any event, there is case law against imposing an inaudibility condition on a licence should a nuisance be found. It was further stated that a new DPS had taken responsibility for the premises with some 38 years experience, and he has made recent attempts to engage with the neighbours and will continue to do so. Nevertheless, it remained clear whether Mr. Dyer's concerns were as a competing business or a concerned resident. And since taking over, he had been working to change direction of the business as a result of the pandemic. For example, the marquee will no longer be erected, outdoor speakers in the rear had been removed, and the hot tub is closely monitored. Further, staff will keep music to background level only, monitor noise levels, and guests using the hot tub will no longer be issued with a Bluetooth code. It was stated the review application had been taken very seriously, and it was hoped that this would be a starting point for an ongoing conversation with neighbours, as it was not in the Bird's interest to cause undue disturbance to its guests, neighbours and local residents. In determining the applications, members were careful to take account of relevant written and oral representations and balance their competing interests. Whilst members were mindful of other statutory regimes, however, they were careful not to duplicate these. Therefore, members disregarded issues such as private nuisance and nuisance arising under the Environmental Protection Act, matters arising from water runoff from a shed, light pollution, party or boundary wall issues, and planning matters. Moreover, privacy, civil property rights, business model, competition, and smoke-free zone issues were disregarded, as were allegations of intimidation and harassment, as they all fall outside of the Licensing Act regime. Members asked themselves whether the recorded music could be described as incidental, and noted it was a matter for them to decide on the facts of the case. Members therefore noted there was no charge for entry to the premises, guests were not arranged as an audience, and the venue was not advertising with music as an attraction, for example, such as a nightclub. Accordingly, when taken together with the photos and videos, members do not find the music had the potential to undermine the prevention of public nuisance objective, and concluded music outside was not capable as being treated as a licensable activity. With regard to public nuisance, members were aware it was for licensing and responsible authorities to consider what constitutes public nuisance and what is appropriate to prevent it. Further, members reminded themselves that public nuisance is not narrowly defined in the licensing regime, and it's important to remember that prevention of public nuisance could include low-level nuisance affecting a few people living locally. However, whilst noting music was audible in neighbouring gardens, neither the police nor the environmental protection team had made any representations. Members therefore found music in these circumstances could not reasonably be described as falling within the scope of the Licensing Act. In all the circumstances, and whilst encouraging the parties to continue discussions, members did not find the matter met the Licensing Act threshold, and accordingly take no further action. Thank you, Chair.
Thank you very much, Mr. Lewis, and thank everybody who's either watched on YouTube or attended the meeting today. And at 12:47, I am bringing the meeting to a close. Can I wish you all the kind of Christmas and festive period in 2021 that you wish